Hey everybody, welcome to the Shanty. I know I'm a day late, probably going to be $1 short too. I apologize for that, but it's been that kind of month this week. So last time we talked about, I think about the FTC rules. I told you we were going to talk about the DOL rules on the Fair Labor Standards Act and raising the salary level test. And that's what we're going to do. Now, we've already done a very short little e-bulletin on this, an e-alert that was combined with some other stuff. So you guys know the basics, but I want to go through it again just to be sure. What this new rule does, and it was published on the 26th of April, 2024 in the Federal Register, so it's going to go into effect on July 1st. What this new rule does is that it raises the salary level test for being an exempt employee under the Fair Labor Standards Act under the so-called white-collar exemptions. You've heard all this before because the Obama administration tried it in 2016. We'll talk about that. The Trump administration did it in 2019, and we'll talk about that briefly too. But let me just give you the basics of the rule. And what they've done this time is slightly different. It's a two-step rule now. So when the rule goes into effect on July 1 of this year, the salary level test will go up from its current level of $684, I think it is now, to $884 a week. $884 a week. Now that translates, if my math is correct, to $43,880 a year. But that's not all. There's another step. On January 1st of 2025, it goes up again. This time to $1,128 a week, or, again, if my math is right, $58,656 a year. So we're going from the current $35,000 and change level by January 1st of next year up to $58,656. Now, that's not all. There's also an automatic calculator built into this thing. Starting on July 1 of 2027, the level gets recalculated using the same formula they used to get to these numbers and could potentially be cranked up again, depending on what's going on in the country, and every 3 years after that. And it does that without new rulemaking. There would just be a thing published by the Secretary of Labor in the Federal Register saying this is what the new level is going to be based on this math, and here you go. In addition, the highly compensated test for highly compensated employees goes up to $132,964 on July 1st and $151,164 on January 1st, and that gets cranked up every 3 years too. Now, as I said, this was published in the Federal Register on April 26th. It goes into effect on July 1st if there's no lawsuit challenging it, if it doesn't get enjoined. Now, none of us have been panicking too much about this, and by the way, I'm not suggesting that you panic, because we all expected the lawsuit to be filed. There's actually a current lawsuit still pending on the 2019 rule, and we'll talk about that. But the lawsuit has not been filed yet, at least as far as I know. And I'm not the only one that looked. I reached out to everybody in the group, to Allison and DeAndre and Rob and John Koch and all the associates, and said, hey, does anybody know where the lawsuit is on these DOL rules? And they all responded, if they responded at all, with the same answer, which is, no, we haven't seen anything about the lawsuit. So let me give you a little history about where we are, and then we'll talk about what we do. In 2016, the Obama administration tried the exact same thing here. Now, they took a huge big jump. It wasn't two-stepped. There was an automatic accelerator in that rule too, where every 3 years the rule would reset, and that was immediately challenged in a federal court in Texas by the state of Nevada in a case called State of Nevada versus U.S. Department of Labor. And in that case, the court held, quote, "It is clear that Congress defined the exemptions with regards to duties." The court then went on to say, with that said, the department does not have the authority to use a salary level test that will effectively eliminate the duties test. In other words, what they said was, your jump is too big. You're eliminating the duties test. Your jump in salary is too big. Biden board learns from that. So the DOL lost. They were told they couldn't do that. They appealed. But the appeal didn't go anywhere because Obama was not in office anymore. Now we have a new Department of Labor, and it's President Trump's Department of Labor. So they dropped the appeal, and they wrote their own rule, and that came out in 2019. Now, the 2019 rule raised the salary level test again to what it is right now, but not nearly as much as it was raised before, and they didn't have the automatic accelerator in it. But that rule was still challenged in a case called Mayfield versus U.S. Department of Labor. And in that case, the plaintiff in that case, rather than arguing that the jump was too high, argued that the Department of Labor didn't have the authority at all to use a salary basis test that, in fact, or a salary level test, or either, frankly. In fact, what the plaintiff argued in that case was, when Congress passed the Fair Labor Standards Act and made these exemptions in the statute, they did it based on duties, not based on salary. All right? Now, at the district court, that plaintiff lost in Mayfield. And the court said, actually, the DOL does have the authority to create a salary level test. And they did that based on a thing called Chevron deference. Chevron deference is a legal document from a case called Chevron. It's a Supreme Court case where the court says agencies that are charged with enforcing statutes and writing regulations are entitled to certain amount of deference by the court when they're interpreting those statutes. All right? So the district court in Mayfield held that the DOL does have the authority to impose a salary test, a salary level test. The court held that that rule, the 2019 rule, was entitled to Chevron deference under the Administrative Procedure Act, and the rule was therefore valid. Now, that case was appealed to the Fifth Circuit Court of Appeals, and that's where it's sitting right now. And as of today, when I'm recording this, oral argument has not been held in that case yet, but it's been briefed, okay? So it could change. The Fifth Circuit could disagree with the lower court and say, no, the 2019 rule is not valid either. And a couple of things have changed in the interim, all right, between when the 2016 rule was overturned and the 2019 rule was affirmed by the lower courts and is up on appeal. First of all, the Supreme Court of the United States, in a completely different case involving a completely different administrative agency, the Environmental Protection Agency, has significantly called into question the Chevron deference doctrine. The Supreme Court is going, wait a minute, maybe we're giving too much deference to these administrative agencies. And we've had a flurry of rulemaking here. Now, we got the FTC rule on non-competes. We've got the rules on the Pregnant Workers Fairness Act. We've got this rule, and there's another rule on migrant workers that we haven't talked about, and we're not gonna. So the Supreme Court has called into question the Chevron deference doctrine. Now, that might cause the Fifth Circuit in the Mayfield case to say, okay, we're not going to grant as much deference based on the Chevron deference doctrine because the Supreme Court has called it into question. And it might not cause them to do that because Chevron deference is still the law. But if this thing gets to the Supreme Court of the United States, there is a likelihood that the Supreme Court will reconsider the Chevron doctrine, in this case or another one like it. The second thing you need to keep in mind is that this rule is way more like the 2016 rule than it is like the 2019 rule. All the 2019 rule did was raise the salary level test a little bit, okay? Now, he raised it from the 20-something thousand that it was up to the 35-something thousand that it is now. This rule, while it does it in two prongs now, they got smart, it does it in two prongs, shoots it all the way from the current level of 35 and change up to 58 and change, which is the gap kind of we had in the 2016 rule. The other thing this rule does that the 2016 rule did is it's got this automatic increase without new rulemaking, which the court's not going to like, I don't think. Now, the DOL got smart when they passed this rule because they put a severability clause in it. And they said, if any part of this rule is found to be invalid, the rest of the rule stays in place. Now, we'll have to see what the courts do with that. Whether they say, no, you can't do that, the rule's bad and it's bad, or whether they don't. We'll have to see. So what should you do given all of this? We've got July 1 coming up. And as of right now, this thing's going into effect until and unless somebody sues. I don't want you to panic. But you should start thinking about what jobs you have in this gap. Now, the gap on July 1 is going to be at 43,888, but on January 1, it's going to be at 58,656. That's a pretty substantial gap. So you should start thinking about what happens in this gap. And remember, this doesn't mean if the rule goes into effect that you have to give everybody raises. You have a number of options about how you can deal with this. And again, I don't want you to panic, but you should start thinking about it. And as you're thinking about it, you should call your Warren Norcross and Judd labor lawyer, and we can help talk you through the options that you have should this rule go into effect, because you do have options. There's a number of things you can do that we will be happy to discuss with you. So call us if you need us. See you next time.